put out some literature
Right.
on a case, so
Right.
if you wouldn't mind sharing that.
Absolutely. I can tread on, I'm not too close to the chalk line on this one, so I can carefully talk about it. 1099s, look, any loan, whether it's a residential mortgage loan, a car loan, credit card debt, any money that you borrow or your clients borrow that's not repaid in full must, according to the federal accounting standards, the FASB rules, that the lenders are subject to, must be reported to the IRS as forgiven debt. Okay? It's not a choice. So 1099s will always be issued on any configuration of loans that are resolved through either a short sale or a trustee sale. The deficiency, the amount that's left unpaid after the sale, will be reported under a 1099. Now, there's been a whole lot of talk over the last 18 months, and I've been a primary party to a lot of that talk philosophically in Arizona, as to whether or not the issuance of a 1099 by a lender following a trustee sale or a short sale results in a legal waiver or relinquishment by that lender of the balance that is due from that borrower from a civil liability standpoint, not from a tax standpoint, guys, but whether or not that borrower could be sued to collect the balance. And my personal opinion was, yeah, it should. Why? Because it's an objective, conscious act by the lender to do something through a third party, the IRS, that causes an impact upon that borrower, a taxable consequence. They may well have to pay taxes. It would make all the sense in the world to say, you know, if you're going to do all that, then you've forgiven the debt, and so you can no longer enforce it. How can I be held to pay taxes on a debt that's been forgiven, and yet the lender can still sue me? December 29, 2009, the Court of Appeals in Arizona ruled on a case on exactly that issue. Unfortunately, the court recognized that, while it recognized that there's a split of authority in the country, some states say yes, some states say no. In Arizona, the court sent it back down to the trial court for further determination. What does that mean? It means right now, there is no rule, and that means right now you cannot tell your clients or give your client any assurance that just because B of A sends a 1099, which it will after a short sale, does not mean that you're out, does not mean that your home's safe, does not mean that that owner of that note could not sue you for the balance. It does not mean that. And in that particular case, it was a car loan, $30,000, the guy stops paying, car loan company repos the car, sells it for $12,000, $18,000 deficiency, sends the IRS an $18,000 1099. Yeah, in that instance, the borrower paid taxes in that tax year on that forgiven debt. It's ordinary income. Paid taxes. 2 years later, he gets sued by Amherst Bank on the note. Says, wait a minute. You guys reported me, I paid taxes, how does this all work? No, that's an objective act. You knowingly, willingly, intentionally released and waived the balance of the debt. Trial court said yes. Bank said no. We were just complying with federal regulations. We have to do this, there's accounting rules, but we did not intentionally waive our right to sue the borrower. So they're in the fight. The trial court agreed with the borrower. But it went up to the Court of Appeals, and the bank argued there has to be something more. Rather than just complying with federal law for accounting purposes, there has to be something more, an objective act. The Court of Appeals agreed, sent it back down to the trial level for further determination on those facts. So all in Arizona right now, it doesn't have any impact. And I know a lot of your clients